The next limitation is regarding the descriptive use of a trademark. It is important for you to understand the distinction between the descriptive use of a trademark and the trademark use of a trademark. When you use the trademark to describe the kind of goods, the quality of goods, the quantity of goods, the purpose of the goods, the value of the goods, the origin of the goods, or the time of production of the goods, when a particular trademark is being used to identify the source of the goods, then it amounts to trademark use of the particular mark. For instance, if you take an Apple phone and see the Apple logo on that phone, it attempts to show that the phone originates from the Apple company. However, let's say someone else is making Apple iPhone chargers and says on its charger that the charger is for use in an Apple phone. Let's say the use is not in a trademark sense to the extent that there is no prominence which is given to Apple or the logo on the charger. In these cases, it would be considered a descriptive use of the mark. So therefore, you can use a mark in such a sense that it indicates the kinds of the goods, or the quality of the goods, or the quantity of the goods, or the intended purpose of the goods. Here, for instance, the intended purpose of the charger is for that it can be used for Apple phones. Thus, the use of the term Apple with respect to the charger will not be considered an infringement. Let me go on with the list. You can use the mark with respect to show the value of the goods, the geographical origin of the goods, the time of production of the goods, or other characteristics. There is a very important caveat here. You cannot use the trademark in a sense by giving it any prominence, but it is important that these trademarks must be in the same font, must not be given any emphasis when they are being used on the chargers. Therefore, at best, the person can write for use in Apple phones without any emphasis on the word Apple whatsoever. Some examples of the descriptive use of a trademark. For instance, the trademark sugar free. In this case, what happened that a subsequent person wanted to use the trademark sugar free with respect to cookies. You might have heard of the sugar free tablets which are used for lowering the sugar content which is given to consumers. The defendant in that case took the defense that he is merely trying to describe the characteristics of his cookies which are free of sugar. The court agreed. The court said that the use of the mark sugar free was only a descriptive use and did not infringe the trademark of the owner of the mark sugar free. Another example is the trademark low absorb. This trademark was used with respect to oils. The court said that even though the plaintiff had the registration for the mark low absorb is only describing the characteristics of the good, and therefore the use of the trademark low absorb would not amount to infringement of the plaintiff's trademark. Let's now move on to the next exception. The next exception is the non-brand use of a trademark. For this purpose, please see section 30 clause 2 clause D of the Act. It says, a trademark is not infringed where the use of a trademark by a person in relation to goods adapted to form part of or to be accessory to other goods or services in relation to which the trademark has been used without infringement of the right given by the registration under this Act, or might for the time being be so used if the use of the trademark is reasonably necessary in order to indicate that the goods or services are so adapted, and neither the purpose nor the effect of the use of the trademark is to indicate, otherwise in accordance with the fact, a connection in the course of the trade between any person and the goods or services as the case may be. Unfortunately, the section is quite long and complicated. Let's try and break it down. What this section really means is whether a person can use the trademark of another to show that the goods that he is selling are adapted or are in some way connected to those goods. Let me give an example. There was a person who was making gaskets for Hawkins cookers. He wanted to use the term Hawkins on his gaskets, on the packaging of his gaskets, to show that those gaskets are compatible with Hawkins cookers. The court was then considered the question, when would it be that the case of use of the trademark being reasonably necessary in order to indicate that the goods are adapted to another? The court said that it must be reasonably necessary, with necessary meaning inherent in the situation and reasonably meaning that it should be just. In that particular case, the gaskets were not only adapted to Hawkins cookers but to several other cookers. The court said that since the goods were compatible with many manufacturers, it was not reasonably necessary to use just one manufacturer's trademark, and therefore section 30 clause 2 clause D did not come to the aid of that particular defendant. But I hope you understand the general principle. When you are making goods which are compatible with the goods of another manufacturer, you may be able to use the trademark of that other manufacturer, but again the same caveat applies, that you cannot use the trademark of another manufacturer in a larger font or with any emphasis. You can only use the trademark to show that your goods are compatible with another manufacturer. This is called the non-brand use of a trademark. Now let's move on to the other exceptions mentioned in section 30. This one is pretty obvious, where the use of the trademark falls outside the scope of trademark protection. For instance, sometimes trademarks are registered with geographical limitations. Let me give you an example. Let's say there is a sweet shop in Delhi by the name of Gopal Sweets, and Gopal Sweets is the best sweet shop in Delhi, and people immediately know that a particular sweet comes from Gopal Sweets when they eat it. Clearly, Gopal Sweets is distinctive and people associate the particular goods with a particular trademark. However, there may be several Gopal Sweets all over the country. Therefore, when Gopal Sweets in Delhi will want to register a trademark, it will probably have to tell the trademarks registry that it will only protect the trademark within Delhi but not in other parts of the country. This would also mean that if some other Gopal Sweet comes up in another part of the country, it will not infringe the trademark rights of the proprietor in Delhi. This is the second to last limitation. Let's move on to the last limitation. What if you apply the trademark to goods which originate from the proprietor? For instance, the proprietor sells the goods not in loose packets but in large bulk pieces. What if while reselling those goods, you apply the trademark of the proprietor on those individual pieces? In absence of section 30 clause 2 clause C, it would amount to trademark infringement. But under section 30 clause 2 clause C, if a trademark is applied to indicate the true origin of the goods, then it does not amount to trademark infringement. Let's now summarize the different limitations that we have studied today. We first studied the limitation of doctrine of exhaustion of rights under which the rights in a trademark get exhausted after the first sale of the goods. The question is whether India follows the principle of national exhaustion or international exhaustion, and the Supreme Court will consider this question in the near future. The next limitation is with respect to suing the registered proprietor of a trademark. There is a lot of ambiguity because there are different sections which seem to say different things. But the Delhi High Court has recently reconciled all these provisions and come to the conclusion that while a suit for an infringement of trademark can be filed against a registered proprietor, the court will have to look at the prima facie invalidity of the defendant's registration before passing any order of interim injunction. Then we talked about the descriptive use of the trademark, and where a trademark is used to describe a quality of the goods. You may recall the sugar-free example where the defendant were using the trademark sugar-free to merely describe the characteristics of the goods and thus was not held liable for trademark infringement. The next limitation is with respect to the non-brand use of a trademark. Here we discussed the Hawkins example. It is important to know that a non-brand use of a trademark must be reasonably necessary, and thus it is usually a difficult defense to take. The last limitation that we studied was with respect to the use of a trademark on the registered proprietor's goods. You may recall the use of a trademark on individual packs when a bulk pack is bought from the trademark proprietor. Where the trademark is used to indicate the true origin of the goods, it does not amount to trademark infringement. I hope now you have a sense of the defenses that are available to a defendant when it is sued for trademark infringement. Thank you.